Hi guys, Sanbonani, Hopuniapilo, Alwande Jabalala, an admitted attorney of the High Court of South Africa. I am back with a third episode on the legal series. Today we are actually discussing unfair dismissals. Tell me, have you been unfairly dismissed, or do you think that you've been unfairly dismissed? Then this video is for you. Obviously, you have to be an employee for someone or for a company. Please stay tuned in and make sure that you watch up until the end because we've got such great information for you guys. Thank you so much once again, and don't forget to like, share and subscribe. And I just want to provide you with the disclaimer: this does not constitute as legal advice. Should you be faced with a legal predicament, it is best that you consult your attorney in order to be able to try and resolve your scenario. Let's just start off by defining what is an unfair dismissal. According to South African law, an unfair dismissal refers to the termination of an employee's contract or employment without a fair reason or without following a fair process. For the purposes of this video, we will keep on referring to the Labor Relations Act. In short, it's the L.R.A. So the L.R.A. provides for the protection of employees against unfair dismissals and sets out the procedures basically that employers must follow in order to terminate an employee's employment contract. This is basically to safeguard so that one day you don't wake up and your employer just fires you. So, in order for a dismissal to be fair, it must be proved that a dismissal is both substantively and procedurally fair. It's a two-legged test. For substantive fairness, the employer is actually required to prove substantive fairness at the disciplinary inquiry. Number one, a breach of a rule. The employer will need to prove that a rule or standard actually existed that the employee breached. The employee therefore contravened that rule. For example, the employer will need to provide evidence to support that breach of a rule or rule of thumb, and therefore that is based on a balance of probabilities. Generally, I just want to inform you guys that it's actually inappropriate to dismiss an employee for a first-time offense, except for misconduct or serious cases or the gravity therein. For example, it makes the continued employment relationship intolerable. Examples of mysterious misconduct subject to the rule, of course, are that each case should be judged on its own merits. That's the first thing. For every video, I'll keep on referring you guys to tell you that each case is based on its own merits. Yes, we do use precedent, previous case law, to actually work on one's favor, but at the end of the day, the commissioner, the judge, magistrate who's actually looking at your matter will look at it from actually your own merits, and therefore they can pull from precedents, previous case law in order to justify, but at the end of the day, ruling will only be based on what you have presented and the evidence herein. So, for example, gross dishonesty or willful damage to the property of the employer, physical assault of an employer, a fellow employee, client, or customer, for example, and gross insubordination. So, for those ones, it doesn't even have to be a second offense. You can just dismiss an employee based on that employee has contravened a certain rule. Now, let's look at the legitimacy of that rule. In this case, even when it has been proved that the rule existed, the employee had contravened that rule, yes, the chairperson still needs to apply his or her mind. The chairperson, now in this case at the disciplinary inquiry, needs to apply his or her mind on whether that rule is valid or reasonable. For example, you assaulted a fellow employee as well. That one, you see, even if they're applying their minds, they'll be like, it has caused an intolerable working relationship with the employer and the employee, which therefore subjects this, for example, to it being substantively fair. And therefore, we look at consistency, where the employer applies the rule consistently. In this case, has a previous case of theft been favored herein? Have employees, somebody's caught red-handed stealing something from the employer and they are able to come back to the office and as if nothing happened? What happens in this case? Or somebody has actually assaulted somebody, except there has been insubordination from other employees. So consistency of the rule is definitely double-checked herein. Also, don't forget, guys, even your HR policy, they serve as a guide, because there will be some misconduct policies herein where they'll tell you if you are found stealing, if you are found contravening something, it's a straight dismissal. You will not even get a first warning. So even those policies, they're a guideline herein, so that for you to double check the consistency part as per the substantive fairness requirements, the employer will need to make sure that some of these things have actually been explained or even thoroughly dealt with on the document, which forms part of your HR policies, of which, if you recall, on our first video, when I spoke about drafting of contracts, I specified that you have to request all of your HR policies when you are working in a work environment, for example, so that you know what rules are there, and if you break a rule, what you are subjected to. Because it's so sad now when you are facing, for example, an unfair dismissal or of some sort, and they're telling you that you contravened a rule, and you are adamant that you didn't even know that this was a rule, for example. But in a way, the employer doesn't even need to tell you not to steal. It's just wrong to steal, especially to steal for your own to steal from your own employer. But for some people, they'll feel like that needs to be in writing. Even if it's not in writing, guys, theft is theft. It's a crime on its own. You can actually be prosecuted for that. But for now, the employer just decides on dismissing you. Let's look at the appropriate sanction. You cannot just dismiss someone for reporting late for duty, for example, as it constitutes a first-time offense. Obviously, you'll issue them with counseling herein or find out what's the reason. However, if an employee was dishonest, there was theft involved, should sufficient evidence be presented herein to support that breach of a rule, the employee can be dismissed, even in the case of a first-time offense. The fact that you were caught on camera red-handed printing paper from the printer, obviously, whatever your justification, for example, is the start of a school year, your kid needed it, whatever your justification, you can be dismissed even though it's a first-time offense. However, unlike somebody, for example, now who came in late, let's just say work started 8, they came in here at 8:05, and it's a first-time offense. But then as time goes by, what will happen if you are constantly late? Now HR intervenes and asks you, is there a problem? Why don't you wake up early, etc.? Up until they are tired of you, they'll give you a verbal warning, they'll give you a first warning, they'll give you a final warning, and then maybe it might even lead to a dismissal, because every day you are constantly late. Guys, don't just come late at work and say, oh no, I won't be dismissed. There are cases whereby constant late coming, for example, if the company can also qualify and say that you coming in late, you are disturbing the schedule because the machine, for example, was meant to start running at this time, but then now that means we are behind on production, so that one can end up being justified. Let's just now look at procedural fairness. Remember, I told you guys that it's a two-legged test. Here we are trying to double check firstly that in as much as you've been dismissed, was your dismissal unfair? So for a dismissal to be fair, it needs to be substantively fair. I've specified from A up until D, and then now we are currently looking at the second leg, procedural fairness. Procedural fairness constitutes procedures used by a decision maker rather than the actual outcome reached. So therefore, it requires that a fair procedure be used when making a decision. So number one, the employer must inform the employee of allegations in a manner that the employee can understand. Guys, you can't just be dismissed if you don't know what you dismissed for. You have to be told that it's for misconduct, it's for incapacity, etc. Therefore, the employee will therefore be allowed reasonable time to prepare a response in relation to the allegations. In most cases, they'll provide you with a charge sheet to say, oh, we're actually charging you for this and that. And therefore, the employer must be given an opportunity to state his or her case during the proceedings, in this case, the disciplinary inquiry. Okay, the employee has a right to cross-examine the initiator, any witnesses brought forth by the employer. Guys, in a disciplinary hearing, you're not just there to keep quiet. You're also there to cross-examine whatever evidence has been led by the employer. If the employer says, we caught you red-handed stealing, ask for proof. Where is the proof? The proof, for example, might be a camera recording on a specific date, or might be a witness who actually saw you. For example, a security guard, when you were leaving, they actually found sugar in your bag, or one of your colleagues actually saw you stealing and putting that sugar from the kitchen in your bag. So you see, that's the evidence. And obviously, you need to cross-examine that evidence and make sure that you are questioning. Remember, you are building a case here in as much as you won't be a lawyer, but whatever evidence that is presented, you have to be able to equipped enough to make sure that, okay, I'll be able to question this. That is why this video is so informative. Like, this video, because it actually prepares you should you one day be faced with such situation. I just want to let you know that we live in a wide environment. You might not think that this will be applicable to you now, but for information purposes, definitely do tune in, because in as much as you might think it's far-fetched, anything can happen. I receive phone calls where somebody is crying and saying, I don't know what happened. I was so happy. I'm in a good mood. Next thing, I'm getting a dismissal informing me that I've been charged with ABC. A disciplinary hearing will be held on this date. And this person, never thought such would happen. So I'm just informing you guys that never say never in this world, because anything can happen. It can happen to you. As good as you are, they say no good deed goes unpunished. Maybe you wanted to assist somebody. Maybe, for example, security guys are mostly independent contractors hired by from external parties. Maybe security guy was feeling cold, they needed some warm beverages. You decided to give them sugar so that they can make coffee, and for that maybe the company sees it as theft, because it's actually leaving the premises, it's going downstairs by the boom gate, etc. So all of that constitutes you at least knowing where you stand legally. Guys, in as much as Ubuntu works, but sometimes if the employer is prejudiced, if the employer sees that, I'm paying so much for sugar in this organization, it actually constitutes as theft. You can try and make a case at the CCMA or any relevant bargaining council by stating that, guys, I was just doing Ubuntu, the guy was cold, etc. But the employer can ask, at whose expense? Why didn't you take your own money and provide them with that sugar? But that was just an example, guys. I was just trying to notify you that anything can happen. So now you're at a disciplinary hearing. We are trying to determine if this was procedurally fair. Now, the employee has a right to be assisted by a shop steward, should they be recognized union in that workplace, or other employees during the proceedings. So if you don't have a shop steward, another employee can represent you. The employer must inform the employee of any decision making regarding a disciplinary sanction herein in writing and in a manner that the employee can understand. Guys, you have to understand what's the outcome of the disciplinary inquiry. And therefore, the employer must give reasons for dismissing the employee. The employer must keep records of the disciplinary action taken against each employee, stating the nature of the misconduct. 1. The disciplinary action taken and the reasons for the disciplinary action. So, guys, again, do you think that you've been unfairly dismissed because A, substantive fairness did not take place, or B, procedurally, none of these things happened? You were just called in, you were told you were dismissed, there was no inquiry, you don't even know what the allegations were, that's it. So, if you've determined that any of this two-legged test, one is in question, then definitely stay tuned in. As we are unpacking unfair dismissals, I also want you guys to know when you as an employee can actually be dismissed. The L.R.A. permits the employer to actually dismiss his or employee for one or more of the following reasons. Misconduct, number 1, by the employee. For example, if an employee is guilty of theft, being absent without authorization, refusing to obey the employer's instructions, and so on. That one qualifies as a dismissal. Incapacity of the employee. For example, when an employee fails to perform a task that they were actually employed to do, maybe based on their ill health, etc. Or operational requirements. Now in this case, the employer, for example, had a drop of sales and can no longer afford the employee. So in this case, it will qualify as operational requirements. So that's when you can actually be dismissed. So in as much as you can be dismissed for the 3, make it all of these actually still need to be met. Your dismissal needs to be substantively and procedurally fair. Don't forget that. If that two-legged test is not met, stay tuned again. Okay, guys. So for dismissals, they are automatically unfair dismissals from the get-go. Let me just tell you what those are before we actually move on how you would refer a matter to the CCMA. So Section 187 of the Labor Relations Act determines what constitutes as automatically unfair dismissals. Number 1, it is definitely automatically unfair if you are dismissed for participating or supporting a protected strike, or for refusing to do work done by an employee who is in a protective strike, or locked out, unless that work is necessary to prevent an actual danger or life of a person or safety or health, or a refusal by an employee to accept a demand in respect of any matter of mutual interest between them and the employer. Another one is for any reason relating to an employee's pregnancy or intended pregnancy. So imagine you're getting dismissed for that. It's automatically unfair. Remember, guys, we cannot discriminate against anybody. Also, for any reason seeking to prevent an employee from exercising his or her rights under the Protected Disclosures Act, or for any reason seeking to avoid the protection for dismissal given to employees in terms of Section 197 of the L.R.A, which refers to the transfer of a business from one employer to another employer, or transferring of a business as a going concern. So if those have been stated, or you feel like your matter qualifies, then automatically that's an unfair dismissal. You see, so definitely just look at the L.R.A. It will definitely tell you in detail what forms an automatically unfair, which means on the go, if any of this takes place, that is an automatically unfair dismissal. You want to refer your matter to the CCMA. Firstly, what do you need to do? Let us just note this, guys, that the CCMA or a bargaining council has jurisdiction depending on the sector that you are in. Now, if it's the CCMA is not the one, therefore you qualify under the bargaining council. So that bargaining council has jurisdiction, or the CCMA, to conciliate unfair dismissal disputes as set out in the Labor Relations Act. The organizations herein also have jurisdiction to arbitrate all but automatically unfair dismissal disputes unless the parties consent in writing for arbitration. The labor courts will have jurisdiction to adjudicate on any automatically unfair dismissal. So if your dismissal is automatically unfair, the labor court has jurisdiction to adjudicate on that matter. So as an employee now, you feel like, as I specified above, that no, I honestly believe that I was unfairly dismissed. I have just checked out L.R.A Jabalala's video on YouTube, and there was no substantive fairness. There were no grounds for the dismissal. There was no procedural fairness done. So my dismissal also does not qualify as an automatic dismissal. As L.R.A has mentioned, none of those things were applicable. So now I want to refer this matter to the CCMA. I'm still here to give you all of that information. So as an employee, whenever you wish to lodge a dispute of unfair dismissal to the CCMA, you must do so within a specified period. Since you are speaking of unfair dismissals, it takes 30 days. 30 days of the date of dismissal. Or when internal appeal procedure is followed within 30 days of that outcome. To work out when a date of dismissal is, please take note that in terms of Section 190, subsection 1 of the L.R.A, the date of the dismissal herein is the earlier date of the date on which the contract of employment was actually terminated, or the date on which the employee left the service of the employer. So herein is 30 days, which is inclusive of your weekends and public holidays. So actually from the day you were actually dismissed, 30 days starts counting from there. So if you're dismissed on the 30th of March, your 30 days starts counting from the 1st of April. So by the 30th, you should have lodged your unfair dismissal claim to the CCMA. However, Section 190, subsection 2 reads that despite what I've mentioned above, that you'll be dismissed on the date, for example, you get your letter, that will qualify as a dismissal date. Herein it says, if, for example, you were actually notified that your contract won't be renewed, or that, for example, your contract is now renewed on less favorable terms, that qualifies as the date of when you are actually dismissed. Or another one, if the employer refused to allow an employee to resume work, the date of the dismissal is the date on which the employer first refused the employee to resume work. So you come into work on the 15th of Feb, that's the day. And the employer says, no, don't work. That's the day you're actually dismissed. Another one is if an employer refused to reinstate or re-employ the employee, the date of dismissal is now the date on which the employer first refused to reinstate or re-employ that employee. You see, guys, whatever scenario that keeps on happening, you take that date. That's the date of dismissal. In this case, if an employer terminates an employee's contract on notice, the date of dismissal is the date on which the notice expires, or if an earlier date, the date on which the employee is paid all outstanding salaries. Now we're done. We've determined how you need to work out these dates, right? So that on that 30-day mark, you are still within. So if you as the employee have now decided to lodge a dispute, What you need to do, you need to complete a CCMA case referral form, also known as the L.R.A. form 711. These forms are available at the Department of Employment and Labor and the CCMA website. Once you've completed the form, you need to ensure that the copy is delivered to the other party, in this case the employer, and you must be able to prove that a copy was sent. And in this case, the acceptable methods for delivery is: one, you utilize a sheriff, and you must know that you pay from your own pockets the sheriff's fees, because a return of service will have to be provided. Or number two, you utilize an email. For example, if you know that there's an HR email address, you definitely use that email address, and you make sure that when you're sending an email, you utilize the red receipt or the delivery receipt on your email. You have to turn those on so that when it says delivered, or they've even read it, you keep that as proof that it was actually sent and delivered, as long as you've sent it to the employer. Or you can actually utilize fax if they are still using a faxing system. Or you can send it by registered mail and therefore you need to keep the postal receipt, to show that you've actually sent it. Or you can just utilize a courier by keeping proof of the delivery, for example, and therefore you can just go in person. And whenever you go in person to the employer, whoever signs for it, you need to have proof as well. You have to make sure that the employer signs, or you've got proof somewhere that if you are sending it in person, that there's receipt. In most cases, some companies will have a stamp that will definitely qualify. When you're done with that, you will have your own copy, the employer's copy, and the CCMA copy of the 711. So you'll give a copy to the employer to ensure either by the above mentioned methods, hand delivery, courier, mail, fax, registered post. When you're done with this, you've got 2 copies left. You now need to send the other one to the CCMA. Also, for the CCMA, you can actually send it in person. If not, you can send it via email. You post it, fax it as well. The information is on the CCMA website as to the details or the email address that is relevant. Now, once that is done, the CCMA now will definitely inform both parties of the date, time, and venue of the first hearing. The first hearing is called conciliation. Only the parties, the trade union, or the employer's organization representatives, if the party to the dispute is a member, for example, and the CCMA commissioner, will attend this conciliation. Not lawyers, unfortunately. Your lawyer can be sitting outside of the room, but they won't go inside because it's still conciliation. The purpose of a conciliation hearing is to reach an agreement acceptable by both parties. Therefore, hence legal representation is not allowed. However, now, just because you guys are conducting a conciliation hearing, it doesn't automatically mean that everything is going to go smooth. If no agreement is reached, the commissioner will issue a certificate to that effect. Depending on the nature of the dispute, the case may be referred to CCMA for arbitration or the labor courts as the next step. So now, what is arbitration? Somebody might ask. Basically, arbitration is like a formal process now. It's like we're now in courts, in as much as we're not in courts. It's a formal process wherein evidence, including witnesses and documents, may be led or may be necessary to prove one's case. The employer can bring in their own evidence, just like you as the employee, So in this case, the parties may even cross-examine each other. Legal representation now in this case is allowed. Your lawyers, we are now allowed to go in for an arbitration now, because that is where we go head to head now with the employer and the employee, making legal representation and making sure that one's case is heard and the other one, what are they doing? They are cross-examining right now. Whatever evidence that is put forward, you cross-examine. That is how it basically is. And therefore, when that is done, the commissioner will make a final decision, a binding decision, an arbitration award within 14 days. But if a party does not comply with the arbitration award, that's when you can refer the matter to the labor courts. So now I want us to look at the 711 form, the L.R.A. form that you can actually download from the Department of Employment and Labor or the CCMA website. So if you are looking at this form, you're definitely going to see referring a dispute to the CCMA for conciliation, including CON-AP. That's a mixture of conciliation and arbitration in one. You need to firstly provide your details. Details of the party referring the dispute. In most cases, it is usually employees who are referring the disputes. I'm not saying that an employer or trade union can't on employer's organization, but I'm just saying for the purposes of this video, we are looking at referring a dispute from the employee's side. So therefore, in this case, you will tick as an employee, the names of the parties. Number one, your full details herein. Your name, your length of service, your surname, your ID number, the gender, your salary, your nationality, your email address, your cell phone. The cell phone is very important because they do send out SMSs or even emails. The CCMA sends that when they're notifying you when your conciliation date has been set. Definitely make sure that you guys are providing the correct details. And also, when you're looking at the alternative contact details of the employee representations, make sure that it's somebody, number one, that you trust, somebody that you are close to, not somebody that you hardly speak to. So, for example, if the CCMA wants to contact you, they can even contact you on that alternative number that you have provided. Your mother, your siblings, your father, your partner. In most cases, those people will qualify as people who are actually in close contact with you. Now, moving on, we are now on the next section. Name of the referring party if the referring party is an employer. So in this case, this one is definitely going to be applicable from the employer side. Number two, the details of the party with whom you are in dispute. Now, if it is your employer, for example, and as I said, in most cases, it's employees who refer these 711 forms. You will state the other party, it's an employer or etc. Then you provide the full names, the names of the company, where they are situated, their address, their email address. If you have like the company registration number, great, put in as much information under this section as possible. Now let's look at section 3, the nature of the disputes. Guys, if you can see just from section 3, you will note that the nature of your disputes can be either or of these. These are just examples that they've put in. But for the purposes of this video, we made an example of dismissals. So in this case, you'll definitely tick the first box, which refers to dismissals. But just for your ease of reference, you can see that we have severance pay, unfair labor practice, freedom of association, unfair discrimination, organizational rights, disputes relating to collective agreements, etc. So even in future, even if your case is not based on a dismissal, the 711 form can actually guide you as to how or what dismissals you can actually send through to the CCMA. The next step is they're saying, if it's an unfair dismissal dispute, tick the relevant box herein. Okay, so in this case, let's look at misconduct. We made an example about theft. That forms part of misconduct. So you'll take misconduct. But if the reasons are unknown, because some people are actually dismissed for unknown reasons, you state reasons unknown. So number 4, where they say summarize the facts of the case. You see that section, as limited as it is, make sure that you also provide limited information. Don't give out your full case herein, because if you are adding witnesses already, you are actually assisting the employer with their case when they need to be presenting evidence. Just state as limited as possible that I came to work on the 15th of March and my employer just told me that I need to go home. I no longer work here. I asked for reasons. I asked for a charge sheet. I asked for any allegations. They didn't give me. Since then, I've never been contacted, for example. So that is why I'm lodging a dispute. You see, keep it as simple, but also just summarizing that you never received a dismissal letter, 1. Number 2, you were told by word of mouth, there was no disciplinary inquiry. Don't now say, so-and-so, my shop steward was next to me. Don't bring in all of that information. Leave that to when the case is actually ongoing at the CCMA. Section 5, the date and the place where the disputes arose. The disputes arose on, you specify the date, the month, the year, and where. For example, if it's in Johannesburg, state that, because that determines the jurisdiction of your CCMA. Your disputes can't arise in Durban and you are referring the matter to, I don't know, anywhere in Johannesburg. So that is very much important. The date of dismissal is also applicable. Remember, I informed you guys how we need to determine the date. That's now where it comes in very handy. In section 11, now they're asking you fairness or unfair dismissal, if applicable. So if you note that A was not done or A was done, then they'll ask you, was the dismissal procedurally unfair? If not, you say no. As per what I've stated above in the video. And therefore, for substantive issues, what's the reason for the dismissal unfair? If you don't know anything, you're not sure if it's for misconduct, whatever, then you say no. But if you know, then unfortunately say yes. and therefore the results required. Herein, it's just your wish, what you want. Do you want reinstatements? Do you want compensation? What do you want? Then you just summarize basically what you want. Number 9, the sector now that you belong in. If you belong in retail, you just tick whichever one that you deem applicable. If you don't know, you say, if it's something that is not listed there, you just mention it now. In Lemnyama, number 10 is very much important, because should you not understand, it is best that you ask for an interpreter. Guys, English can be very troubling sometimes, especially under legal proceedings, because they use the legal jargon in as much as the commissioner may shy away from it. But remember, when the employer is delivering their case, they will not go easy on you guys. They will make sure that somewhere, somehow you are confused. Lawyer for the employer will be providing legal jargon. Uzokhuluma into ngempela isiPutukezi into ongayizwa. Othi mawulalele prima facie proof jurisdiction uvela uthi mina ngazi man kuthiwa ndani. So make sure that you request for an interpreter. Whether you are black, white, Indian, whatever race, make sure that you request for an interpreter. So in this case, there will be Afrikaans, Xhosa, Setswana, isiNdebele, isiZulu, Tshivenda, isiSwati, isiPedi, konke. Click there. Which one is applicable? It means that when you are now sitting at that conciliation, whenever they speak, somebody will be interpreting for you. Whenever they speak, somebody will be interpreting for you. And another thing, the reason why I'm saying that, not everyone has the privilege of having a lawyer at the proceedings. Some people can't afford a lawyer. Sometimes there was no shop steward. There's no some people represent themselves at the CCMA at arbitration. So now, if you don't understand even the simplest English, you're gonna have trouble, because it means that you might end up losing your case just because of simple English or simple words. That is why sometimes if ungazi kulungile usizo lukhona, an interpreter will be there to tell you exactly what that other party is saying. And if you don't understand, again, ask them to clarify. Don't just take their word for it. If you are not understanding what is actually meant, ask them to clarify. And then section 11, if it's a discrimination matter, you also click. You just follow the steps. If it's discrimination disputes, you note yes, have you attempted to resolve, etc. You note all of those things. And therefore, section 12, you need to confirm the above details. Print your name, that you are the one who's actually submitting this form, etc. That's basically the 711 form that you actually need to fill in when you are referring your dispute to the CCMA. This form now, as I've stated, you'll be given a case number. You'll be notified either via text, email, or in writing via post, maybe, that when your case is now going to sit down at the CCMA. So guys, in conclusion, just to summarize, we have looked at what is an unfair dismissal. We have looked at what qualifies as automatically unfair dismissals. We have looked at the two-legged test for unfair dismissals, whether it was substantively or procedurally fair. Okay. Now we've also looked at how you can be dismissed, or what qualifies as dismissal, reasons for dismissal. For example, misconduct, incapacity, operational requirements. That you can actually be dismissed for 3 of those. And therefore, we also looked at how to refer a dispute to the CCMA, the timeframes that are involved, and we looked at the section 11 form. This information is mainly a guideline to assist you. It does not qualify as legal advice. Should you want a labor or employment lawyer to look at your case, please make sure that you utilize them, especially if you can afford, because you wouldn't want your case to go south. It is very traumatic going through such experiences, especially if you've never been. It is best that you ensure that if you can afford, you utilize that. However, if not, I hope this video will set as a guideline for you, so that one day, should you ever be involved in such a matter, you'll know very well that, you know what, even though I just watched the video, I was able to put my case forward, Hence, I said, even if you might not understand English that well, since it's the medium of instruction in CCMA proceedings, you will ask for an interpreter, which means already you know that you want to gain an advantage. And lastly, that I just want to tell you guys, whenever you go to the CCMA, please do look presentable. Do not look as if you are going to a jolly good place. Take it as court, in as much as you are not in court, but it's still a formal process altogether. Look presentable. You might not be wearing the fanciest suit or have the most expensive hairstyle, but just look presentable in a way that will make sure that the commissioner sees you. Remember, guys, people look at you and be like, But if you're wearing something that is just opposite of your case. In as much as you might have like a strong case, you must also have confidence. The way you walk, the way you talk, whether you speak broken English or you speak broken Zulu or whatever, just make sure when you get there, you are firm, you are confident of your case, because that assists. Even the commissioner can see that you are passionate. You know exactly, that, okay, this person knows what they want here in. You must know what you want before you go out. You tell the commissioner that you want to go back to work, or if you feel like you can't go back to work, you tell the commissioner that I actually want to be compensated here in. So definitely make sure that all of those things, you look at them way before going into the CCMA, because it does assist your case. Remember, you might or might not have legal representation. Your employer will come in there guns blazing with attorneys, etc., and you only come alone. But people have won cases against their employers if they've been able to prove. Make sure that your documents are in order whenever an employer leads the case. Now, once you have proved that you have been dismissed, because, for example, you had to prove that you were dismissed, you have a letter of dismissal, whatever, you have a communication that they said you don't need to come to work. Remember, he who alleges must prove. That's on you. But after that, the onus shifts to the employer to check whether the dismissal was unfair or not. So now, whatever evidence that the employer is leading, you need to cross-examine that witness, or that document that was done. For example, if somebody says they saw you stealing sugar or tea or coffee, you ask them questions. They say to them, when last did you take leave, for example? They say, I last took leave in April. Then you say, please provide me with the dates. Then they give you the dates. You're like, okay, the day that I'm actually charged with stealing is the day you were absent. Then how did you see me stealing that sugar? You see, you're questioning their witness. Guys, if you have watched trials, come on, right now SA is very big on broadcasting trials online via YouTube and all of these media platforms. You know now that you want to put question marks on someone's case. So whatever that is presented, you make sure that you cross-examine, and the employer will do so as well. This is just to strengthen your case and make sure that you leave no stone unturned. With that being said, I hope you enjoyed today's session. Guys, in as much as labor law dismissals is quite a big topic, we can never finish it in one go. So now what I've definitely done, I've summarized the issue for you. So please do stay tuned in, and don't forget to like and subscribe to this channel. I hope you have a great day. From Mam Shengu, with love. Ngiyabonga kakhulu.